rise. The Court of Appeals Division 1 is now in session.
Please be seated. Good morning.
Good morning.
Good morning.
I thought I was supposed to respond. I'm sorry.
You're just excited. You want to chime in. Good morning. You can be seated. We are here for oral argument in case number CV210013, Clementine versus Ruhorimbere, and I apologize for butchering that. Each side has 20 minutes for argument. I don't know if you've practiced in front of our court before, but the appellant may reserve time, some of that 20, but it's the appellant that must do so. So there should be some clocks over there. So just keep track of it yourself. Our proceedings are being audio and video recorded and live streamed. Please introduce yourself and your client at the start. We've read the briefs. We've discussed the case this morning at conference, and we are familiar with the arguments raised. I would ask that you please keep that in mind when making your arguments. So with that, you may proceed, counsel.
Good morning, Your Honor. My client is Mayra Clementine and Mayra Fabrice, and we already would probably stipulate that if I use appellee and appellant, that would probably be make the argument a lot shorter with the names, the Rwandan names. My client, I think, is here telephonically or watching that because they said that they had that option. My name is Ken Bemis. I'm an attorney for the plaintiff, co-counsel with Mr. Cliff Levinson, who's to my left. I'd like to reserve about 8 minutes. I think you implied that it was my duty to watch the clock, which I see.
It wasn't an implication.
It was an order?
Not an order, just an advice.
All right. I'd like to emphasize from the beginning that my clients gave the appellees money and never received reimbursement in return for any of it.
Counsel, this was a bench trial?
It sure was.
Okay. How long did it last?
2 days.
How many witnesses?
Probably about a half a dozen.
And so it's coming to us from a judgment issued after a bench trial. What is the standard of review?
The standard of review is, to be honest, more difficult, and we should have asked for findings of facts and then conclusions of law.
What's the standard of review?
I think it's something to the effect that on the facts that you have to accept them. I'm trying to find them in my notes, and I'm having a little bit of stage fright here, I guess.
Let me ask you another question.
I've got it. No.
So the court issued a judgment for your colleague's client, right?
Correct.
Is there any evidence, and I understand that you think the weight of the evidence might have been in your client's favor, but was there any evidence in the record to support that judgment?
I don't think there's evidence or any evidence given the fact that my clients gave the appellees money and they didn't get anything in return. I think that you can look at the facts in the law, and I don't think that standard of review will pass muster.
The defendant, Eri, I think is his first name, H-E-R-I, did he testify?
Yes, he did.
And he said there was no agreement.
But it's blatantly false.
Did he say there was an agreement?
He said there was an agreement.
He did. What was the terms of the agreement?
There was a written agreement.
Was it the one you alleged in your complaint?
It was introduced into evidence, and I don't believe it was alleged in the complaint.
Did defendant R.A. agree with your client that there was an agreement with particular terms that the parties entered into?
I believe he did. I cited a discussion back and forth between the appellee and the trial court judge, and it kind of frames it right there. I don't think that you're entitled to just go on the standard of review that you're talking about and see that what the appellee states, which is complete fabrication, can be grounds for just telling me to sit down and it's over with.
Right. This is the Court of Appeals. We weren't there for the trial. We didn't have the chance to assess anyone's credibility. We have a record, and it sits there, and it either has enough evidence, which isn't a high standard after a bench trial, or it has no evidence. It doesn't have that evidence. And my understanding, and I think you might be representing to this court that I'm wrong, is that there was an agreement, that there was an agreement, and it had certain terms. I thought R.A. took the stand, and he denied that such a contract existed.
Well, I'm just reading it right from a quote from him, and the court says, okay, and you drafted this agreement and helped draft it. That's about page 156, line 9 at SAC.
So you're representing this court. I want to make perfectly clear that there was no evidence introduced during this 2-day trial that would have supported the factual findings, I guess we have to assume, the court made because none were requested. That's your position.
I think that given the facts, and if you look at the colloquy between the...
colloquy? That's not evidence.
It is when the guy's testifying under oath.
Who's having... Well, I don't know what you're...
Maybe I'm using the wrong word, but...
A lawyer talking to a judge is not evidence, but go ahead.
Okay, well, I'll learn something new every day when you're on the stand and the judge is asking you questions. I thought that the oral testimony is evidence.
So they were asking questions. The judge was asking questions of the witness. That was... And what was the question that you're... If you can read it to me.
It says, this document says the two parties involved are on one side, appellee, I'm paraphrasing, and the other side is appellant and appellee. I say he wrote the agreement, and the judge says, okay, and you drafted the agreement or helped draft it? As you say, voluntary, is that correct? Well, not me. It's actually, I drafted it. It was both us sitting together, and that process was voluntary. It was, and it was a different agreement that was entered into evidence.
Right. So, if let's say, and I haven't read that, but if you draft an agreement, is that sufficient evidence of whatever you need to show in a consummated agreement, meeting of the minds, whether it's signature or not? I mean, I'll go back to the record. You understand? That's not changing. Those words remain fixed in time, and I will be able to see if there is no evidence that would support the trial court's findings. And so I'm reticent to engage in this on this particular testimony. But, okay, what other evidence, other than this paragraph, this colloquy, or the judge asking, questioning the witness on the stand, what other, I guess I was asking the opposite, which is there any evidence to support the court's judgment? And you said no, and then you went to, again, which is what I was saying at the beginning. I'm sure you think the evidence weighs in your favor and in your client's favor, maybe even substantially so or slightly so. But my question was, is there any evidence in the record to support the actual judgment? Not to support your client?
I'm reticent to say that when the appellee admits that he had an agreement, admits he never paid any money back, and I respectfully think that if you're doing something in the interest of justice, just to say that if there's just one iota of evidence, then I lose, or else I wouldn't be standing here. So,
After a trial? Well, okay. Keep going.
It's undisputed facts we're dealing with. This is another quote. Did Lillian give money to the business? Well, yes. When she gave money to the business, it was just at the start of the business. At the start of the business, yes. This is the parade. He admits. So how much did she give? If all put together, I think it was around $62,000. What I want when a appellee has to take the stand, I want a query of how they can take the position that they can get funds and not have any obligation to pay it back just because there was a bench trial and I wasn't there to at the time make requests for findings of facts and conclusions of law, which would have changed the standard of review, of course. But he admitted he signed the agreement, but he comes up with this convoluted argument that I guess you could say constitutes evidence. I think it's, if you look at it and see that it's clearly facetious or disingenuous, then I think you would listen to me more. He said it was really tough having a wife who's pushing you to let this family be a part of the company. And I told them there was no way for them to come into this company until we started a new company. And from that's what put the idea together to start to convert this company into a corporate entity. Lillian, that's his wife, was pushing me to give us something, and that you agree because you're not going to go back and rely on her.
Okay, so let's go on to the next point that you raised, which was the absence of factual findings and conclusions of law. You weren't trial counsel?
No.
But you said if you were, you would have asked?
Most of the times there's been bench trials when I haven't, but I will say I was reluctant to. I regretted I didn't.
Okay, and why?
Because it changes the standard of review. And there's facts that we can look at.
It changes the standard of review, how? Or is there presumptions? Are you sort of incorporating presumptions into that standard?
Well, to be honest, I'm always honest, of course, but when I was looking at the standard of review, I was looking at the standard of review when there wasn't a request for findings of facts, but it is a different standard.
And that's why when you didn't ask for them in the past, you wished you would have?
Yes, and then judges get real aggravated about that, and then they turn it back on us and they say, well, you write up the findings of facts and conclusions of law. I guess that's their option, but that's what happens in reality.
Right.
This isn't my first rodeo.
Yeah. Well, okay. So you have 7 minutes left.
I reserve that time for rebuttal.
Okay.
Thank you.
Thank you. Counsel.
Good morning. Please, the court, my name is Roger D. Smith. I represent the defendants H&L Devotion LLC and the individual defendant Ruhorimbere, who for convenience purposes we just call Harry. Harry was formerly married to Lillian Nyambo.
So counsel, let's get right to it. Is there any evidence in the record to support the judgment?
Yes, there's
Give
overwhelming.
me some.
Well, first of all,
Not necessarily words from testimony, but,
right, the complaint alleges.
well, that's not evidence.
Right, but the complaint alleged there was an agreement in 2015.
Okay.
For an
You're framing the lawsuit.
Right.
Okay.
Okay, so they alleged there was an agreement whereby for a sum of money, they purchased the right to profits. They didn't become partners. They didn't have a role in the company. And they admit that it was an oral agreement. There was nothing in writing in 2015. When I say there's nothing in writing, there's no agreement, there's no letters, there's nothing but the plaintiff's oral testimony. The defendant said there was no agreement, they didn't invest anything. So on the crucial issue of the case, there is evidence to support that there was no agreement made and no money given, so therefore the judgment is supported by the record. Plus, certainly the trial court could have disregarded the plaintiff's testimony as inherently unbelievable.
And we don't know because there's no, what, findings of fact?
There's no findings of fact, but certainly it's not unusual that the trial court would have rejected their argument in that they couldn't even describe the terms of the agreement. At first they say they invested $62,000, then they filed a complaint when they said there was an oral agreement whereby they invested $85,000. That complaint got dismissed and they filed the present complaint and they alleged they invested $170,000. Then in the disclosure statement and the pretrial, it came back to 85. But then at trial, when 85 didn't fit in with their theory, they just changed it and said, no, the agreement was for $95,000. But then they agreed they didn't pay the $95,000. There was a subsequent oral agreement, which isn't confirmed.
But the point is, we don't even have to, we don't have findings of fact and conclusions of law. So what does that mean?
That means that there's testimony that there was no agreement and there was no contribution.
And we have to assume, what do we have to assume if there's no findings of fact and conclusions?
If there's no findings of fact and conclusions of law, we have to assume that the trial judge made every finding necessary to support the judgment. And in this case, that would mean he agreed that there was no agreement and there was no investment. Now, what they're talking about is a document that came months later in 2016 where it doesn't, the document they're relying on does not confirm the oral agreement that they alleged in the complaint. It does not confirm that there was an agreement by non-partners to divide profits. If anything, it's a separate deal that had nothing to do with the complaint. It's entitled a partnership agreement, and it says that the parties agreed to form a new company to buy the existing company.
So, counsel, I'm assuming that this was all the subject of your client's testimony during the bench trial, what you're recounting here.
Correct.
Okay, so this is all testified to in the record.
Correct. So they didn't sue on an agreement to form a new company. They sued on an oral agreement to share profits by non-partners. And in fact, at trial, in the closing statement, they specifically argued this document that we're relying on didn't create a partnership. They're saying this document actually confirms an oral agreement to share profits by non-partners. So their argument is the trial judge was required to reject the actual words of the document and to interpret it some other way. Plus, there was testimony, and this is a testimony they keep referring to. There's testimony that the trial judge could have reasonably found that this document that they're relying on didn't create an agreement at all. It was just the initial negotiation about the possible creation of a subsequent entity to purchase the existing company, and then they never followed through with it. So the testimony and the evidence shows that Harry and his then wife, Lillian Nyambo, created a company in 2015. They were the only members of the company. They were the only investors in the company. The only money that was put into the company was their joint property and the sole and separate property they had at that time. Months after the company was in business, Lillian started to pressure Harry to let her brother and sister-in-law join the company. That was impossible because it was an LLC taxed as an S-corp, and you can't have foreign investors. So Harry and plaintiff Fabrice sat down and brainstormed ways that they might be able to bring them in. And one of the ideas was to create a new company to purchase the existing company.
So you're arguing that this letter is really an agreement to agree. It's equivalent to a letter of intent.
Well, the testimony was that they didn't come up with any final agreements. There's nothing in the document that says how much the plaintiffs have to contribute to buy into this company. It was just the initial discussion. However, in order for the plaintiffs to raise the money if they were going to finalize this deal, they would have to sell off assets and so forth. So they wanted something in writing that would confirm that if they did come to a final deal, that Harry would go through with it and form this new company. The testimony is they never finalized it. They never did anything. They never paid the money, and the matter was just dropped.
Okay, so because you just heard counsel, your colleague over here, read testimony that there was money that was given, $62,000 that was given. What's your response to that?
That's the money at the very beginning, when Harry and his then wife put their community property and their sole and separate property into the company. This thing they're talking about is months later, and there's no evidence that they contributed anything to the company.
So you're saying that the record reflects that Ms. Nyambo contributes $62,000 to the formation of this company, but that $62,000 is her sole and separate property and maybe some part of their community?
Correct.
Okay. And but with regard to the plaintiffs, to Fabrice and Clementine, there's no evidence that they contributed any of that $62,000.
That's correct. In fact, they admit they did not give any money to the defendants. They say they gave money to Nyambo, but then they didn't sue her.
Was there documentary evidence to support that?
They admit they didn't give any. They admit that.
No. You just said that they said that they gave money to Ms. Nyambo.
Right.
My question is does our record reflect any documentary evidence to support that statement?
Zero. There's not a canceled check. There's not a wire transfer. There's not a receipt of any kind. All it was the plaintiffs said they gave money to a family member with no backup information at all. And in fact, the plaintiffs made no claim to this company at all until Harry and his wife, Nyambo, were engaged in a highly contentious divorce case.
So, just to round this out, even if there was such evidence, what you're telling me is that Harry would dispute that money exchange took place. Did he deny that took place? That Ms. Nyambo received money?
He wouldn't know. All I'm saying is there's no evidence. There's nothing other than their self-serving testimony. Plus, not only is there's zero evidence that they actually gave money to Nyambo, there's zero evidence that if they did give money to her, that she gave it to Harry or invested it in the company. Again.
Right, so his testimony, the testimony in our record is that Harry did not receive use of that money from any source that wasn't Nyambo's or their community money used in their business.
Correct.
So he never got anything
Right,
to use in the business, and the business never received anything from plaintiffs.
that's correct.
Okay, so is that a correct understanding of the evidence in the record?
The evidence in the record is there's no evidence that money came from Nyambo to the plaintiffs or from the plaintiffs to Nyambo and from Nyambo to Harry or the company.
So there's conflicting evidence in this record.
Well, the only conflicting evidence is the plaintiffs say they gave money to Nyambo. We don't know if that's true or not. There's no proof of that. But there is definitely no proof that she then turned around and gave that money to Harry or to the company. So there's evidence that the trial court could say there was no agreement. There's evidence that said if there had been an agreement that the plaintiffs satisfied their duties to pay any money. Thirdly, there's no evidence upon which the plaintiffs can prove damages. They claim there was a breach of contract. They claim...
Why are you arguing about what, no evidence? I mean, you won. I mean...
Right.
So
the trial judge reasonably could conclude that the plaintiffs did not meet their burden of proof. There's no evidence to support that there were any damages whatsoever.
Right. Well, the record evidence, there's a disagreement, and the trial court made a call.
Correct. So I can go through the defects in their damage, but there's evidence upon which the trial court could have reasonably concluded that there was no agreement, there was no payment, and there were no damages. So we would ask the court to affirm the lower court and to award us attorney's fees and costs on appeal.
Thank you, counsel. Counsel.
Thank you, Your Honor. The parties entered this agreement to operate this business at 50% share of profits and losses. Interest will be distributed to owners on a monthly basis. This is the agreement. This is what they gave. This is what we have a problem with. That he argues that there's no evidence, but I put it in my brief that they just completely ignore his obligations under Rule 26.1. The days of trial by ambush are over. So he had an agreement. The testimony is cited in my brief that he admits that it was given it to his wife. There's not a shred of legal argument that says that you can't give money to another person in the business, and the wife was a person in the business. So just to say that he gave the money to the wife, or the parents gave the money to the wife, is kind of a red herring. So I've been hit on the standard, and the standard is clearly erroneous. I'll agree to that. There's any reasonable evidence, and when you look at the agreement and look at the conduct of the parties, and you look at the testimony that I quoted you, I asked you to see if you could get it out of appellee's counsel where that money went, and there is no answer, because it's not within the spirit of Rule 26.1 or any other equitable law or legal law for that matter.
But counsel just stated in his argument that the $62,000 came from Ms. Nyambo, her sole and separate property, and maybe some of their community property, and that money was used for the business, but that money didn't come from Ms. Clementine or Mr. Fabrice.
Lillian testified, and it's on the record, and that's appellee's wife, soon to be former wife. So she testified, and there was no just because all of a sudden it's a relative. There's nothing clear. There's nothing even close to where the appellee says that he didn't get the money, he didn't use the money.
The contribution of Ms. Nyombo to the business would give Ms. Nyombo an interest in the business, not plaintiffs.
It's not. If you're talking about Lillian, it's not her money. It was given by my clients to Lillian for the business, and they were both parties in the business, Lillian and the appellee. Now, I put it in my brief. Perhaps she got, Lillian was perturbed because appellee was not being forthright with my clients, but they did get a divorce. But that doesn't change any of the facts that she was a person in the business. That argument is just, I can't wrap my brain around it, because I think I said, like, if Bezos wanted to buy 5 boxes of printing paper from Staples, there's some other exceptions, of course, but that he had to sign it, and he was going to make a contract. Let's just say it was over the statute of frauds amount. That to say that his wife had to sign if he was married, because he signed it, that he's not liable. I just don't think that's true. So I think if you look at his testimony, he'll admit that he received the money, and then there was subsequent testimony that there was no money to give back because they had costs for labor, which they couldn't use to show that they didn't make a profit, because their accountant said they made a profit. But the fact is that it's a pretty fair inference that if they couldn't get Social Security numbers of the employees, they couldn't deduct it. So on one point, the appellee can be untruthful about his earnings to the government, and on the other hand, you can say that there's some inference that he didn't get the money. Then I ask you again to ask him where the money went. He's not denying that he got money. I respectfully disagree that you're saying that he just got it from his wife. He got it from the appellant.
I'm just saying what he said, and what counsel represented to us is that the character of his testimony was that he received that money from Ms. Nyombo.
Who got it from the plaintiffs, and he agreed to that too. So
that seems like a conflict of evidence, does it not?
I'm not of it.
You have one party testifying to one characterization and one party testifying to another characterization. That strikes me as a conflict of evidence, which was resolved at bench trial by the trial judge.
I don't think it is resolved at bench trial if his testimony was clearly erroneous. That's not reasonable evidence. That's the standard of review. That's not reasonable evidence.
Why is it not reasonable evidence, sir?
Where did the money go? Where did the money go? He'll never answer that question if you ask him 100 times. He signed the memorialization of the agreement, and he argues statute of fraud. Am I out of time?
Almost.
All right. Did you have another question?
I don't.
No.
Thank you for allowing me to court.
Oh, well, thank you for coming to our court. Thank you both for your arguments today. We will take the matter under advisement, issue a decision in due course, and we are adjourned.